Good afternoon, everybody. I hope everyone is doing well. My name is Chris Justice. I'm here today again to join you all for some Q&A of all things employment law related. I'm an associate, of course, at the Toronto location of Samfiru, Tumarkin. And as always, I'm happy to take any questions that you may have. I did want to, however, start with a few topics, some more recent events that have been going on in the world of employment law that I think everyone ought to be aware of if they're not already. And so I'll start first with some recent legislation that was passed dealing with the right to disconnect from work. And I may have spoken about this before, and I know we as a firm have spoken about this before. But for those who don't know, there was some legislation passed not very long ago that was aimed at addressing situations where people were being overworked, particularly in the context of work from home arrangements. So, as I'm sure many are aware, a lot of people have been working from home since the pandemic began. And one of the issues has been the sort of the lack of a divide between the home life and the work life, which has led to a lot of employees working longer hours, maybe than typically is the case. And so partly that's why this legislation was introduced to sort of help give people their free time, the space after a long day's work. And I'm not going to really get into the specifics of the legislation for today's purposes, but I do think in light of this legislation, there's a general point that needs to be made, and that has to do with an employer making changes to the terms of your employment. So, for example, if it was the case that before the pandemic, you were working a 9 to 5 job in the office, and after the pandemic, you start working from home and you end up actually working longer hours than what you're accustomed to, you as an employee don't necessarily have to accept the state of affairs in that respect. And so if you've gone, let's say, from working 40 hours a week to now 50 because you're at home, and you know that maybe the practical realities of that have resulted in more work, don't think that you as an employee have to accept those changes necessarily, because you may have an option to reject the change and insist that your employer keep the hours per week to what was agreed upon before the pandemic. And again, that's partly what this new legislation is trying to address. But I think the general point still needs to be made that regardless of what legislation is in place with respect to the right to disconnect, that you as an individual still have recourse and still have options if you're in a situation where your job is dramatically changing in some respect. And that could include hours, compensation, etc. So you don't want something like that to continue on for very long, because you may be seen as having accepted that change, and then that will form a new part of your employment. So definitely something to touch base with legal counsel on earlier rather than later. But I thought I'd start with just making a general point about that, and especially in the context of everyone working from home now. I want to move on to another topic. Actually, it was a news story that came out. I don't know if you may have heard about it, but it has to do with a CEO of an American company essentially terminating the employment of, I think it was around 900 different employees by way of a Zoom conference call or some sort of video conference call. And so essentially what happened is this individual at the company got about 900 employees onto this call, and in a matter of one or two sentences, essentially told everyone that they were being laid off and that they would receive, I think it is a month's worth of severance. And of course, this just happened very recently. So we're talking a few weeks before the holiday break. And all of these employees are being essentially advised in a group of 899 others, along with them, that their employment was over. And so again, this has been a recent story in the news. I don't know if you've checked it out yet, but I just thought in terms of that story particularly, I wanted to raise another general concept, which was the manner in which someone is let go. So we've always talked about, how much severance am I owed if I'm let go from my position? My employer maybe subjected me to harassment or discrimination or whatnot. But the manner, the way in which you are terminated or someone is terminated is also a relevant detail, potentially in a lot of cases. So if, for example, the employer terminates your employment in a particularly bad faith manner, and you could argue that, of course, having 900 people on a Zoom call and telling them that they're all going to be without a job and, here's a month's worth of pay just before the holidays is a bad faith manner of termination. You as an individual may be entitled to more compensation for that fact. There are other situations that I can speak of as far as examples of bad faith manner terminations. Another one would be that I've seen anyways, where someone is informed that their employment is over and then they are essentially escorted, and this was before the pandemic, but they were essentially escorted from their office outside of the building. And there was security present, and they didn't really have any time to collect their belongings. And they were almost in a way paraded through the halls of their workplace before exiting the workplace and, essentially never coming back. And in those cases, there can be a lot of times a great deal of embarrassment, humiliation. So it just, again, goes to the point of how are you being let go? Is it being done in a dignified fashion? Is it being done in a more callous manner, which may or may not result in an impact to you, whether financially or from a health perspective? But definitely something to be mindful of, the way in which you're let go. And so if you feel as though the manner in which you were let go was particularly egregious, then, as I said before, it not only may be the case that you're entitled to greater severance, but potentially further damages for those bad faith actions. And I'll take now a point or time to transition to the third point I wanted to raise as far as recent things that have been going on in the employment law world. And this one applies to Canada. And I don't know if everyone has got a chance to sort of read up on this yet, because it did just happen. But the federal government just came out with an announcement in the context of people who work for federally regulated employers. So we're talking banks, of course, airlines, telecom companies. So if you're an employee who works for a federally regulated business, you'll definitely want to listen to this update. And that, again, is coming from the federal government. They've announced that they will be requiring all employees in the federally regulated context to undergo vaccinations, or at least in order to remain employed with these companies, the government is essentially requiring the employees to be vaccinated. So what is going to happen, if it hasn't happened already, if you work for a federally regulated company, you're probably going to hear about this very soon, that your employer will require you definitively to be fully vaccinated by a certain day. Now, the federal government has mentioned that the mandate with respect to these employees and with respect to the vaccination is set to take effect in the early part of next year. So that could very well be January. If it's not later, it could be as early as January of 2022. And given what the government has said, given that the government has clearly stated that they are looking to mandate vaccines in this particular industry or sector of jobs by early 2022, if you're an employee in that situation and you end up losing your job after, and this is a key point, after the mandate comes into effect, then you are likely going to be without many options, unfortunately, in terms of severance. That could change, and I wouldn't say that 100% of the time you will have no option. But given this announcement and given this mandate, it's going to be, as it stands now, almost next to impossible, unfortunately, to get severance in those situations. However, if you lose your job, if you're let go, if you are placed on an unpaid leave of absence, and you are in a federally regulated business, and this happens before the government mandate takes effect, then you still are likely entitled to severance. And you still could potentially also be entitled to further damages, depending, again, on the way in which things unfolded. So the timing of your termination, the timing of your leave of absence, if that's what happens to you, will be crucially important. Again, with that sort of rough timeline of early 2022 being very relevant. So definitely, I think a general blow to those who work for federally regulated employers who will not be getting vaccinated even into the following year. Not necessarily, black and white. There are, of course, always situations where even if you may think you're dead to rights, you have options. And again, I'll just reiterate that the timing in which you're let go, or the timing in which you are placed on a leave, will be important. And I'm not aware of a specific date as to when this mandate will take effect, but I'm sure that we will hear about it probably very shortly, and get an update from the federal government in that respect. So definitely wanted to raise that in case everyone wasn't aware. But I would also suggest either you can get in touch with us at our firm to discuss these situations a bit further if you have some questions, and also definitely check out the release from the government itself, which can be accessible online through their website. And but yeah, otherwise you can find out more on our website, and we'll probably have a lot of people calling in asking about this, and so you should expect to see a lot of information coming out from us, specifically addressing this federal mandate and what may very well follow. So with that said, I appreciate you guys taking some time to let me explain all that, but I will now get into some of the questions, some of the comments. So please do send them in if you've got anything. It doesn't have to be related to COVID-19. It could just be a question you have about something that's happened in the workplace. It could be maybe a question you have before accepting an offer of employment, or getting into an employment relationship of some sort. Or it could be a question of something that you have in mind after you've left the company, whatever those circumstances may be. So yeah, just bear with me. I'll get to some of your questions. Thanks as always for everyone in submitting their questions and comments. I've got one comment here from Jeannie on Facebook, and she asks, or rather says, "I've lost my job and now I'm denied EI." And what I will say on that point is that, especially recently, there have been a lot of employees who have either been terminated for not complying with the COVID policy of their employer, or they've been put on an unpaid leave of absence for not complying with the COVID policy. And they subsequently go and apply for EI, which I think is the right move to make. I think if you are someone in need of money, especially, and you've lost your job for an alleged breach of COVID policy, I would still recommend you go and apply for EI. Now, unfortunately, it does seem to be the case that a lot of people are being denied EI, and that Service Canada or the ministry are essentially saying that you're not entitled to EI if you choose not to comply with your employer's COVID policy. And what I will say, first of all, is in my view, that's unfortunate, because I believe, and as do my colleagues, that in the vast majority of cases, people who lose their job for not complying with a COVID policy, that is not a situation that arises to the level of a just cause dismissal, which ordinarily would disentitle you to EI benefits. And so in our view, there should be an entitlement to EI. Even though people are getting denied EI, Jeannie, what I would say to you and to others that may be in your situation who have been denied EI is to either, well, number one, contact a lawyer, get in touch with us, and that very well may be something that we can help out with, because not only are we helping people out in terms of getting severance for breaching an alleged COVID policy, but we're also doing what we can to help people out in terms of getting them EI benefits, in terms of sort of making revisions to the record of employment to reflect the fact that you were let go without just cause. And so that could very well be something, Jeannie, we can help out with. But what I will say, just one further thing on this, is whether it's with our help or not, and you've been denied, I would still recommend that you appeal that decision. I know there are appeal mechanisms in place, and so I would avail myself of that. But before maybe undergoing that, you may want to get in touch with us just to sort of make sure that everything you're doing from here forward is the right step to take. But don't feel too disheartened. It is a weird time right now, so it's hard for me to really say how all of this EI stuff is going to play out. Unfortunately, Service Canada, are their own beast. But I wouldn't give up hope now, and it's just something that I think you'll have to fight for. And as I said before, we've got a lot of people at our firm that can hopefully assist with you and with others in that situation. But thanks again for the comment. I've got another question in here from Mark on YouTube. Mark is asking, what kind of changes to my employment can my employer make before it's considered a major change? And that's a good question, Mark. What I will say generally is that there's no exact science to what necessarily constitutes a major change. And usually the general question would be, if an outsider, if a third party were looking in from the outside and they noted all the changes, would sort of a reasonable, objective person consider those changes to be significant? And there, of course, can be a number of different types of changes. So if we're talking changes in compensation, a lot of times if you're taking a hit compensation-wise of 15% or greater, a lot of times a court is going to consider that to be a major change that you're not necessarily obligated to accept. If your geographic location where you need to report to or travel to is being changed and you have to travel an extra hour one way to get to your office, from a geography standpoint, that could very well easily be considered a significant change. If you're going from a day shift to a night shift, that could be a change. If you're being demoted and you're now lower on the company's organizational chart and maybe reporting to someone who previously reported to you, or something of that sort, that could be a significant change. And in general, if there are a number of changes and maybe there's just more than one or two or three, they don't all necessarily on their own have to be that big, and maybe cumulatively or added up, they can amount to a constructive dismissal. So again, no exact science, but depending on what we're talking about exactly, or in totality, there definitely could be a major change in your case. And if there is a situation in your case, Mark, where changes are happening, definitely want to get in touch with us so we can kind of flesh it out a bit more and let you know, because you don't want to have those changes persist. You don't want to be silent and not object to those changes if you're not agreeable to them. And so it's always good to find out as soon as possible the degree of changes there are and to take action sooner rather than later. And that likely would involve you notifying them in writing as to your objection. But thanks for your question. I know it's definitely something that a lot of people are experiencing nowadays. Just going through some more comments and questions. I've got a question from it's Pear. Forgive me, but yeah, Pear on YouTube is asking, why do companies go from allowing testing as an accommodation? So I take it you mean rapid testing in this COVID policy context, to completely withdrawing testing and then firing employees? That's a good question. That's a very good question. That is a situation that I have personally come across a number of times, where you work for a company says, we'll let you get vaccinated or we will let you submit to testing. Say, for example, you say no to vaccination and you say yes to testing. Everything's all good for all intents and purposes. And then at some point later, the company says, actually, we change our minds, forget the rapid testing. Now it has to be a vaccination. And if you don't get vaccinated, your days are numbered. You're going to be let go. You're going to be put on a leave of absence. And for the vast majority of these cases, I don't believe that a company can do that. It really would come down to whether or not there's any legislation in place in that particular industry that obligates the company to have everyone fully vaccinated, which for the most part is a very rare occurrence. So for a company to switch from giving you those options to now giving you an ultimatum that it has to be vaccination or the door, as I said, there's a very high likelihood that as much as they may want to do that, they cannot do that and get away with not giving you severance. So if they're going to change their position and do that, and you're as a consequence someone who loses their job because of that, especially if you are willing to do the testing or some other alternative measures, then I highly doubt that this employer, this company is going to be able to either let you go or put you on a leave and not pay you anything and avoid its severance obligations. And again, there may be other obligations it has to you as well. So I can't really say why necessarily on that question, but I will say that you do have recourse. So definitely get in touch with us if you find yourself in that kind of a situation, which, as I say, is unfortunately a fairly common situation that I've come across in the last month or so. So thank you though for that question. I hope that answers it. I've got some other comments coming in, one from JC on YouTube saying, in the event an employer keeps adding additional duties, at what point would that change the person's position and entitle them to additional wages? Okay, so I touched on this a little bit before, but in a situation where an employer adds a bunch of duties onto your plate, number one, if it's not with your consent and the duties are significant, then my question is, what benefit are you getting from that? Is it simply the employer just saying, we're going to double your workload and pay you the same? Because if that's the case and you don't get any additional benefit or don't agree to the changes, then like I was saying before, you would have an option to object to those changes and insist that you do what you had signed up to do. And if your employer insists that it has to be their way or the highway, then you could potentially exit that situation, quit that position, which I wouldn't recommend doing until you speak with us, but you could leave that position and essentially argue that you were constructively dismissed. And that would entitle you to severance. So that is what I would say there. Now, only because you use the word entitlement to additional wages, what I would say as well is that if you are contemplating doing more duties, taking on a bigger workload, then as a practical idea, it is always open for you to negotiate with your employer. So for example, if your employer is saying, well, we're going to be giving you double the workload, you could reject that. You could also practically suggest a compromise where you might say, okay, I will only agree to doing this if you increase my pay by, X amount of dollars. So that could be possible, but that would at least need to happen. There would need to be some consideration going both ways. They get a benefit, you get a benefit. But if it's a situation where they're just imposing something on you and not giving you any benefit whatsoever, then that would normally trigger a constructive dismissal and trigger those severance entitlements. So hopefully that answers your question, JC. But if not, or if you have any further information, want to talk about us with it more, with us more, you can get in touch with our firm. But thanks again. So bear with me, everyone. I'm just going through some more questions. I've got a comment from M. Ted on Facebook, and the comment or the question is, Does or can harassment and bullying fall under health and safety issues, giving me the right to refuse unsafe work? Um, I've been going into the office. It's ruining my mental and physical health. And yes, I've contacted HR to try to resolve, but I'm being ignored or put on the back burner. So that's a good question. Again, unfortunately, a lot of people find themselves in a situation where they are being bullied or harassed in the workplace, and it is contributing to them not being able to do their job. And usually, what I say is number one, as you've kind of mentioned, contact HR. If there's bullying or harassment and the company has an anti-bullying or harassment policy, you may want to consult that policy, find out what steps are being suggested that you take, make sure that you comply with all of those steps, that you report the bullying and the harassment in the proper manner, that you document your concerns in writing. And if you're being given the runaround or you're being ignored, normally what I would say is continue to follow up with them in writing, but after a certain point in time, if they simply don't want to address your concerns and it's contributing more so to a toxic work environment, then I wouldn't say that you should necessarily feel obligated to stick around in that environment. And again, that may be a situation where, especially if you've presented your concerns repeatedly and it's just fallen on, deaf ears, so to speak, for lack of a better phrase, then I think that's a problem for the company. I think that you can potentially exit that situation, claim a constructive dismissal, and get severance rather than sticking around, which could just be worse for your mental health. These types of cases can be tricky, and there can be a lot of dispute and contention with these types of cases. So evidence is very important. And it's definitely not a decision that I would make hastily in terms of quitting my job due to a toxic work environment without first consulting with a lawyer, and without first making sure that everything is in place to some extent if you do need to progress to more formal legal action. So definitely something that you'd want to have the issues fleshed out for before you take any certain action. But at the same time, I would suggest taking some sort of action or initiative sooner rather than later. But yeah, it sounds like you've got something going on there. You've tried what you can do, and they just don't want to listen to you. So it may be a situation where you need to exit for your own well-being, and like I say, hopefully get compensation, particularly if you've been there for a while. So hopefully that answers your question partially there, MTED. Thank you though for that. Sorry guys, just getting to some more questions. There's a lot coming in, so just bear with me. Sorry. So yeah, I've got a question or a comment from Kevin Bayers on Facebook, and the comment or question is, I recently took some sick days rather than vacation time. I had to file short-term disability. It was only 3 days. At the last minute, my employer requested a doctor's note to clear me back to work. But if I took vacation, my employer would never have known. Is this a right request for the employer to make? What difference is there between vacation days and sick time? Well, generally speaking, sick time would be normally used, of course, in the context of someone who's feeling ill. If the company's got paid sick leave, or not, there's unpaid sick time that you can get, that you're entitled to through legislation. Whereas vacation, I suppose, could just be to take a break. Although I know in some cases companies allow people to take vacation days as sick time, just because it can afford them the ability to get paid for that time frame. And I guess it seems like you've made an application for disability benefits. Your employer likely became aware of that, and it seems like they're trying to get some information from you in terms of potentially accommodating a return to work in your case. But I know in these cases, a lot of times employers tend to ask for more medical information than is necessary. So Kevin, I would say it would probably be more beneficial if you contacted our firm just to sort of provide some additional details. I don't want to make any large assumptions here. But if you are someone who's seeking disability benefits, or are asking or telling your employer you cannot attend the workplace, generally some information will have to be provided in support of that leave, whether it's to the employer or to the benefits provider. But at the same time, as I say, you don't want to be giving them too much information, and a lot of times privacy issues can arise. So definitely get in touch with us before doing anything in particular. And otherwise, I hope that was partial help. I unfortunately am not going to be able to get to any other questions. My deepest apologies. I know a lot of people have sent in some comments, and very much appreciate all of those. There will be future sessions as always, though, so definitely stay tuned. We have these Q&As on an ongoing basis. So the next one that's scheduled, do attend, get your questions in, and I myself will be back in the future as well. So I obviously look forward to answering any questions that you guys may have at that time. But I do appreciate everyone again joining me. And do take care. We've got another live event, as you see there, December 9th, so tomorrow, and that's at 4 p.m. with the associate Sandy. So do take care until then. Thanks for everyone for joining, and I'll see you all soon. Take care. Bye for now.